morning and welcome to the Court of Appeals. I want to take just a moment before we get started and just make sure everybody's on the same page as we proceed today. I know everyone's an experienced practitioner, but it's one of those things that I like to do. First of all, let's talk about our procedure. Obviously, everybody understands you get 15 minutes to make your oral argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court after you've come to the podium and introduced yourself, but before you begin your argument. You may reserve up to 5 minutes of rebuttal time. If you're the appellant, appellee gets no rebuttal time. We have a lighting system on the podium. I believe it to be very straightforward. Once you begin your argument, the green light comes on. Once your time is running short, the yellow light comes on, and when your time is used up, the red light comes on. We ask that you please respect those time constraints. One very important thing that I want everyone to understand is that these arguments are being live streamed. The important thing from our perspective is please think about what you're saying as you say it, because once you've said it, it's out there in front of everybody in the entire world, or that possibility is there. So please think about that. Your panel this morning consists of Judge Kenny Armstrong from Memphis, Judge John McClarty from Chattanooga, and I'm Steve Stafford from Dyersburg. Ms. Ashley, anything we need to take up before we call the first case? All right, you may call the first case, please.
Jack Scott v. Tennessee Department of Transportation.
Good morning, Your Honors, and may it please the Court. My name is Ryan Henry, and I represent the state of Tennessee on behalf of the Tennessee Department of Transportation, appellant in this matter. Before I begin, I'd like to reserve 2 minutes for rebuttal.
2 minutes. All right, you may proceed.
Your Honors, the issue in this case is whether the Board of Appeals properly upheld the Tennessee Department of Transportation's decision to terminate petitioner's employment for failure to maintain satisfactory working relationships and failure to report for duty at the assigned time and place. I will provide a brief background on the procedural posture of the case and then provide 2 arguments explaining why this court should reverse the Chancery Court's order granting petitioner's motion to alter and amend and uphold the Board of Appeals findings on the merits. This matter is governed by the TEAMS Act, which requires that the appeal of an employment decision go through 3 steps of review prior to being eligible for judicial review. The first step is a review by the employing agency, here TDOT. Step 2 is a review by the Commissioner of the Department of Human Resources. Step 3 is a review by the Board of Appeals. At that point, an unsatisfied party may appeal for a judicial review by Chancery Court.
Is that an evidentiary hearing?
Excuse me, Your Honor?
Is that an evidentiary hearing? When is a evidentiary hearing conducted in this process?
Step 3 is an evidentiary hearing.
With the administrative law judge presiding?
Yes, Your Honor, as well as a panel of commissioner board members.
Okay, and who makes the decision in that situation? Well, you've got board members and you've got an administrative law judge. So who's the fact finder?
Excuse me. The commissioners are the fact finders. The ALJ is there to preside over these proceedings and ensure that they proceed according to civil procedure.
So the ALJ doesn't make any decisions other than the procedure or evidentiary rulings?
That's correct, Your Honor.
Okay.
So the commissioners make their decision based upon the evidence that's presented to them?
Yes, Your Honor. During the Step 3 Board of Appeals hearing.
Then their decision then will be that based upon and nothing other than what is they actually receive as evidence and whatever they view as evidence. Is that correct?
Yes, Your Honor. There is a technical record that is available for review, but the documents in the technical record are not admitted as evidence unless moved into evidence by a party. Otherwise, the evidence consists of what is put on as testimony at the Step 3 hearing before the commissioners.
Well, in this particular instance, apparently the ALJ ruled that some evidence should not be included or should not be considered, correct?
Yes, Your Honor. There was a motion in limine by petitioner which requested that a specific exhibit on the state's case list, the inmate charge history, be excluded from evidence. That motion in limine was granted, and the document was excluded from the record.
So did the commissioners consider that?
Your Honor, the commissioners did not have the inmate charge history available to them, and they did not consider it in their decision. The Step 3 Board of Appeals hearings are a bit unique in that you can see the commissioners' deliberations are on the record. So if you look at the commissioners' deliberations, none of them mentioned an inmate charge history, and it was not in the record. So there's no evidence that it was considered in the findings.
Well, there must have been something because the administrative law judge gave a curative instruction to not consider this evidence of the appellee's arrest. So how did that arise such that it was necessary to give the curative instruction?
Yes, Your Honor. The Step 1, Tennessee Department of Human Resources is required by statute to provide the Step 1 and Step 2 decisions and complaints to the Step 3 board prior to the hearing. The Department of Human Resources complied with that statute, provided the Step 1 and Step 2 decisions and complaints, and the findings of facts in those decisions referenced an inmate charge history. But the inmate charge history itself was excluded from the hearing.
So the Step 3 hearing then, was there any mention of this excluded evidence other than the ALJ saying we're not considering it by either the ALJ or the commissioners, other than the exclusion itself?
The Assistant Human Resources Director for TDOT gave testimony at the Step 3 hearing. At the conclusion of her testimony, the commissioners are permitted to question each witness, and a commissioner attempted to elicit testimony about the petitioner's whereabouts from January 27th to February 3rd. And the ALJ properly stopped the line of questioning immediately, had a sidebar with the attorneys, and then gave a curative instruction to the commissioners.
Was there any objection to the content of that curative instruction by the appellee?
There was no objection by the appellee to the content of the curative instruction. There was an objection by the appellee to the line of questioning in general. However, the ALJ appropriately handled the situation by stopping the line of questioning immediately and giving the curative instruction. For a bit of context, this was 3 lines in a 243-page transcript. So looking at the totality of the evidence, the mention of petitioner's incarceration was extremely minor.
Assuming that was a significant enough issue or error, something that had been raised that shouldn't have been raised that was a major issue. Can you have I guess for want of a better description, a mistrial or impanel other commissioners? Is there a procedure for that?
Yes, Your Honor. The ALJ could have declared a mistrial. However, the board would have to be reconvened within 120 days of petitioner's complaint. The ALJ noted that that was not a possibility and that the curative instruction was sufficient to move forward with the Step 3 hearing.
Was a mistrial requested?
There was not a formal request for a mistrial. However, petitioner's counsel indicated that had this been a jury trial, he would have been moving for a mistrial. The ALJ did specifically address the issue, that he treated that comment as a request, denied the request, and moved forward.
Okay.
And as far as the mistrial standard, Your Honor, 2 of the 3 factors for a mistrial weigh in the state's favor. So in looking at whether a mistrial is appropriate, the court would look to whether who elicited the testimony and whether there was a curative instruction. In this case, a commissioner elicited the testimony, not the state, and the judge gave a prompt curative instruction, which is presumed to be followed.
So I'm assuming the entire record moves forward to the trial court then. Is that right?
The entire record?
Of the level 3 hearing or stage 3 hearing, once the matter gets to the trial court itself?
Yes,
the
Your Honor.
Chancery Court here. The entire record moves forward. Is that correct?
Yes, Your Honor.
Was there any requirement, need, or attempt to redact the record, to remove this mention of the excluded evidence, or is that necessary?
There was not. Petitioner was free to file a motion to redact the evidence from the record during the Step 3 hearing. He was and he did not do so.
Okay. Is there a need to do that, since it's been excluded from consideration by the commissioners?
I don't believe so, Your Honor. This court's review is on the record, and that is because petitioner did not redact the record at the Step 3 Board of Appeals, it would not be appropriate to, I don't believe it would be appropriate to redact it at this level.
Isn't the Chancery Court's review the same as ours?
Yes, Your Honor.
So, I mean, the Chancery Court's got the record, sees the objection, the ruling, the instruction. So the Chancery Court's in the same position as we are. Is that
Yes.
accurate?
Yes, Your Honor.
Okay.
And the Chancery Court's initial order in this case hit the nail on the head. It is possibly the most succinct and direct document in the record, and it provides substantial and material evidence as to why TDOT was appropriately terminated petitioner. It's the April 5th order gives 4 reasons, 4 specific instances, which ranged from an oral warning to a suspension, for which petitioner received disciplinary action related to abusive behavior towards colleagues. In one instance, he indicated that he would beat his supervisor's eyeballs out of his head. And then the court also gave 6 separate reasons that documented plaintiff's continual leave from work in a leave without pay status.
The stage 3 deliberation by the commissioners Was that open to the public?
I don't believe so, Your Honor, but I do not know as I stand here today.
And did they make a decision that day and announce the decision?
At the step 3,
Yes.
yes, they did.
And the time elapsed between the end of the hearing and their decision, do you know how much time elapsed?
I see I'm getting short on time. Do you mind if I answer your question,
Yeah, go
Your
right
Honor? The findings of fact were deliberated by the commissioners on the record, and they released their findings of fact and opinion at the hearing.
And in connection with the motion to alter or amend, was there a hearing with evidence that indicated that the commissioners were influenced by this evidence of an arrest?
If you look at the record of the Step 3 Board of Appeals discussion, the commissioners did not mention the inmate charge history or the incarceration as part of their deliberations in coming to their finding.
And the trial court on the motion to alter or amend did not hear any evidence that indicated that they were influenced by any consideration of this arrest.
That is correct, Your Honor.
All right.
All right, thank you. You've got your rebuttal time.
Good morning, Your Honors. Jonathan Wardle for the state of, I'm so used to saying for the state of Tennessee, I'm not for the state of Tennessee anymore. I'm here for representing petitioner appellee Jack Scott. The underlying context here, very briefly, and then I want to address some of the procedural issues that the court said, but the underlying context here is that Mr. Scott was fired because he was never able to secure appropriate benefits for his work-related injuries. He was injured in 2017 and again in 2019. He tried to access both the sick leave and sick leave bank and FMLA leave, but his attempts were stymied for procedural issues. He did obtain some workers' compensation benefits, but they were limited, and the authorized doctors released him to work too soon. He even had to go back once off leave, and they released him again. At the time of this, the final absence for which he was fired, he was to receive injections from one of the authorized treating physicians for his workers' compensation injuries. There's no question that he was frustrated with his ongoing pain and his inability to do work because of the injuries. And he was terminated, he was fired because he kept missing work because of his pain related to the injury and the doctor's appointments. And in my brief, I went into substantial detail describing what is in the record about every one of his absences, and almost every one of them was because of this pain and back injury. He followed the procedures as they were explained to him by his supervisor, Mr. Pettigo, which was bring a doctor's note when you come back, and that's what he did. That's the underlying context here, and it's against that backdrop that we're reviewing what was a split decision, not a unanimous decision, by the Board of Appeals to uphold Mr. Scott's termination. To answer a couple of the procedural issues about what happened below, the Step 3 hearing is an evidentiary hearing. It's the only evidentiary hearing on the record in this matter. Mr. Scott's hearing was held via WebEx. It was a teleconference, video conference, and that's important because that means that neither the ALJ nor the attorneys could see what the panel members were actually looking at. And it is clear that what happened is at least one of the panel members was paying attention to this information about Mr. Scott's arrest, which the ALJ had ruled was irrelevant, prejudicial, and inadmissible. It is true, as counsel said, that the exhibit of his arrest record was not introduced as evidence. But I'm going to read here from the technical record, or not the technical record, the transcript of the evidence, exactly what happened. And I'll say that the motion in limine hearing is not on the record, so we don't know exactly what was said. We only have to go by what came out after the panel member asked a question about this inappropriate evidence. The question was, now, was one of the things that troubled TDOT with regard to the absences from January 27th to February 5th an issue that Mr. Scott may have been incarcerated for part of that time?
Who asked that question?
As you said, it was one of the assistant commissioners on the panel. So a panel member asked that. It was one of the commissioners asked to the assistant director. Right. The administrative judge immediately said, all right, there have been some pre-hearing discussions about that information, and it was ruled to be irrelevant. So it's not part of the information that the board needs to consider. And then there was a sidebar. I don't know exactly what happened, but I imagine they closed the WebEx so that only the attorneys and the ALJ were there. And this is what counsel said. Your Honor, the court was clear on that ruling last week that that was not to be discussed. There was not supposed to be anything about any type of incarceration of arrest.
Who said that?
That was counsel for petitioner.
Okay.
The administrative judge then says, well, that was about the jail record. The technical record came in. They're allowed to see the technical record. And I'll give them an instruction that they're to disregard it. Petitioner's counsel says, they're only to determine the proof that was either testified to or exhibits. And this is one of the questions that came up before. I believe what Ms. Henry said here was that the panel makes the decision based on the evidence presented to them. They can review the technical record, but it's not evidence. I don't know how you can give something to a finder of fact to consider and review and not call it evidence. I just don't know how that's possible. And here they were given the technical record. But I'm going to...
Well, did counsel move to redact the technical record?
They did not. But I'm going to point out that there was apparently some confusion about what was in the technical record. This is, I believe...
thought what you just said recognized the fact that this was part of the technical record.
Well, I'm going to read what the ALJ said was in the technical record. And you'll see that he never said that the Step 1 and Step 2 decisions were in the technical record, which is why counsel would obviously not think they were in there. It says, do you have copies of the notice and hearing charges to provide to the board? Yes, those have been submitted. That's the clerk. Then the ALJ says, okay, speaking of the record, I'll discuss the elements that are part of the record. It begins with the due process request that was submitted on May 5th, 2020. There was this Ms. South's notice of appearance. I believe that was Ms. South's, yes. And then we had an order setting a pre-hearing conference. We had notice of appearance by Mr. Taylor. That's petitioner's counsel. We had ultimately the order setting this hearing. We advanced it. There was an agreed order that accomplished that. There was a witness list and exhibit list filed by counsel. And I'll add that after those were filed, that was when the motion for limine was filed to keep out the record of incarceration. Okay, is there anything else, Ms. South or Mr. Taylor, that you believe should be part of the technical record?
Let me stop you there. The motion to limine is filed to keep out the record. You have a pre-hearing.
Not to keep out the record, I'm sorry, to keep out one of the exhibits that was listed in the exhibit list.
Okay, which references the,
incarceration.
okay, and that was granted.
Yes, the judge says, and according to what is in the record, the judge said there's not supposed to be anything about the incarceration or arrest. And when the judge says what is in the technical record here, he never mentions the Step 1 or Step 2 decision, which is the only other thing that mentions the incarceration. All right?
Then whose responsibility is it to remove that from the record?
That is a good question, Your Honor. I would submit that it is the responsibility of the department who maintains and supplies that technical record. And again, the court asked the attorneys, is there anything else in the technical record? Should there be anything else there? And they said no, even attorney for TDOT.
And what exactly is in the record?
Well, what we have before the court does include, the court now, does include the Step 1 and Step 2 decision. But it was not clear to counsel that that was in there. And apparently it wasn't clear to the judge because he didn't mention it.
But what is actually in the record?
I'm going to have to say that when you say the record before the court now, volumes 1 through 5, which contain the Step 1, Step 2. What was in front of the...
What was in the record at the Step 3 hearing that you contend should not have been in the record based upon the motion in limine?
The Step 1 and Step 2 decisions, which mentioned his incarceration.
Mention it in what regard?
So they The state introduced, TDOT introduced at those, they had the step 1 hearing, and so it went up on the step 2, they got to review it, evidence of Mr. Scott's incarceration. It was an incarceration record. That's it. It's just a record that says he was arrested and what the charges were. That's it. And then Mr. Scott's wife testified at the step 1 hearing that it's all resolved, this family matter, it wasn't an issue. The charges, as I pointed out in my brief, don't necessarily mean that he wasn't injured. I mean, this was completely irrelevant prejudicial information. Step 1 had it, and they discussed it in that hearing. So it was in the step 1 decision. And it became important because at the step 1 decision, and again at step 2, the only basis for discrediting the doctor's note that Mr. Scott brought with him when he returned from this last absence, he brought a doctor's note with him. But he was terminated before he had a chance to turn in the doctor's note. At the step 1 hearing, they discredited that doctor's note, and their reason was, well, he was arrested. So clearly this isn't clear.
So the doctor's note attempted to excuse him from work during that period in late January and early February because of an injury, when in fact he was in jail?
Well, Your Honor, he was in jail overnight. There's no question that he was injured. He did have back pain, and during part of the absence, he received injections. Those were planned before all this. The record is also clear that he left work on the 28th of January because of back pain. And that's why I say this arrest record should be irrelevant and prejudicial. People want to assume, oh, he was arrested, he wasn't really injured. But if you analyze the charges, there's nothing about the charges that say he wasn't injured. And he was in jail overnight for a matter that was fully resolved.
At the stage 3 hearing, did the petitioner's wife testify about the
No.
event between her and her husband that led to his arrest?
No, Your Honor, because the arrest wasn't supposed to be at the step 3 hearing at all.
But she testified at one of the earlier hearings, is that right?
Yes, to counteract the prejudicial evidence that really shouldn't have been there but was.
But that was part of the record as well, correct?
It turns out that it was. But
Well, I mean, her explanation is part of the record as well.
yes, it was a short explanation. I am sure that if Petitioner's counsel had known at the step 3 hearing that this was going to be admissible evidence, he would have gone into more detail.
Okay, let me ask you what is a bit confusing to me here. And I want to make sure that we're all on the same page. Which hearing panel are you saying, okay, let me rephrase it, make it a little bit better. The trial court here granted the motion to alter or amend, saying that this information should not have been considered or should not have been in the record, as I understand it. Is the trial court saying that it was the stage 3 hearing panel that should not have been exposed to this information?
Yes, Your Honor.
Here's my difficulty with this. You have an administrative law judge who said, I've granted the motion in limine, this information should not come in. That judge has done what that judge was supposed to do, theoretically here. You have a commissioner who is one of the panel members who, on his own volition, raises the issue and then is instructed, we can't get into that, that's not proper evidence. And I'm paraphrasing here. What else is it that hearing 3 panel or the administrative law judge could have done in this situation?
I have 2 answers for you. The first and obvious answer to me is once the trier of fact is tainted with prejudicial information, it's a mistrial.
Was that asked for?
I'll read exactly what happened there, Your Honor. This is from page 263 of the record, or excuse me, 262. Nope, 264. Here we go, 264. Your Honor was clear that day that was not to be brought in at all. I mean, it clearly was. What's the point of having a de novo hearing if they're repeating everything that's already happened? Prejudiced. And then he does ask, he says, I would, right here on page 263, if it was a jury trial, I'd be moving for mistrial at this point. You made a clear ruling, and now we're at this point at the very last minute. And the judge says, I understand your petition, and as counsel said, he essentially treated it as a motion for mistrial and denied it. And the reason he denied it was not to protect petitioner's rights. The reason was, I don't have a way to reconvene, this panel within 120 days. Well, that's unfortunate, but he's trampling on petitioner's rights because they don't think they can reconvene. in
Was a
120 days.
mistrial requested?
Yes, Your Honor, I believe it was. I believe the record is clear enough that what he said is.
Well,
a motion for
he said
mistrial.
I would ask for one. Did he ask for one?
I read what was asked, or what he said. I would submit that that is sufficient to request a mistrial. It certainly is enough for.
And that you have the transcript. Can you read to us what the commissioner said regarding this arrest that led to the curative instruction in the side panel,
I can read,
sidebar?
I will read what the administrative judge said in response to this request for mistrial, and then the curative instruction that he gave.
No, I'm
Oh, okay.
interested in the question asked by the commissioner. What did the commissioner ask?
The commissioner asked, was one of the things that troubled TDOT with regard to the absences from January 27th to February 5th an issue that Mr. Scott may have been incarcerated for part of that time? Administrative judge responds, all right, there have been some pre-hearing discussions about that information, and it was ruled to be irrelevant, so it needs to be so it's not part of the information that the board needs to consider. Then there's a sidebar, and after the sidebar, he gives the following curative instruction. Mr. Manuel, you were asking questions. That last question you asked is one that concerned information that's in the technical record that's not relevant to the charges, the only two elements, and it must be disregarded by the board. Do you have further questions? He doesn't say why, he doesn't say what about it is irrelevant, and even worse, later on in his instructions for the board, he says, you may consider the technical record.
And there was no objection to the curative instruction?
No,
No request
but
to
the judge-
modify it, to expand it in any way?
There was not, but again, the judge didn't give them an opportunity. I realize counsel could have said, hey, Your Honor, that's not enough. I see I'm out of time, but to answer the question, he could have said, that's not enough, but the judge didn't give them a chance. He didn't discuss the curative instruction with them. We would just submit that the Chancery Court was correct in saying, and this is, I'll point to the Gordon case, it's.
You've used your time.
I have, Your Honor. I may file a notice of supplemental authority because it's a recent decision.
Thank you.
Thank you, Your Honors.
Your Honors, I have 2 points on rebuttal. May I begin?
Go ahead.
First is that the step 1, step 2 decisions and complaints were properly in front of the step 3 Board of Appeals pursuant to Tennessee Code Annotated 83318 I-4, which requires that those documents be provided to the step 3 Board of Appeals.
Did those documents reference the incarceration?
Yes, Your Honor. However, those documents have to be were transmitted prior to the motion in limine hearing. TDOT and the Department of Human Resources could not have redacted those documents prior to submission to the Step 3 Board of Appeals. My second point.
Could the ALJ then have ordered that the documents be redacted?
Yes, Your Honor, at the motion in limine hearing.
Did that happen?
Petitioner did not ask for any redactions to the Step 1 or Step 2 decisions and complaints.
But they did ask for exclusion of evidence.
Yes, and for a specific document, the inmate charge history, which went into detail about the criminal acts that petitioner engaged in. That document was excluded from the record and was not considered by the Step 3 Board of Appeals. And if you look to the record.
When you say excluded from the record, do you mean it was physically removed from the record?
It was not transmitted to the Step 3 Board of Appeals.
Okay.
And
The step 1 and 2 decision Was there any mention of the incarceration in their decision itself?
It was included in the findings of fact. As far as the analysis of the decision, it was not mentioned in the step 1 or step 2 analysis supporting Tennessee Department of Transportation's termination of petitioner's employment.
Okay.
All right, thank you.
Thank you, Your Honors.
Thank you, counsel. We appreciate your arguments, your briefs. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. You may be excused.